My name is Michael Foster, and I'm with Kieran. We're both attorneys at Kirschbaum and Kirschbaum, and we're here today to speak about what really seems to have spiraled out of control. It's coronavirus and the effect on basically you as employers, and what your rights are, what your employees' rights are, and how to approach this what seems like an ever-changing landscape on a day-to-day basis. So just to go through a little roadmap about our webinar today, first we're going to touch on whether an employee can refuse to come in because whether fear of sick or being actually sick with coronavirus or just the fear of it in general. Then we're going to touch on, as employers, whether we can ask them to stay home. Again, same, whether they're actually sick or whether it's just a fear. Then do I have to pay employees if we close? What are the laws regarding, just ignore this. What are the laws regarding pay? Who has to get paid for how long? In terms of paid time off, sick leave as well. We'll touch on that in federal, state, and local laws. And then basically just some proactive policies you can touch on and implement in your day-to-day practice to ensure that you are taking all steps to protect yourself from liability. And then Kieran, I believe you're going to touch on a few subjects as well.
Correct. Other issues that this recent pandemic has raised that are in the minds of employers.
Okay. Oh, sorry about that. Okay, so basic overview. Just the recent outbreak of COVID-19, which is the medical term / coronavirus, presents various issues for employers in the day-to-day operation of their business. All employers have a duty to provide employment and the place of employment which are free from recognized hazards that are causing or likely to cause death or serious physical harm to employees. This quote comes from OSHA's General Duty Clause, which is a federal law. It was intended to protect employees from any, hazardous environments in the workplace, but it can certainly, in some sense, be applied to pandemics and viruses as well. So we'll touch on that a little bit later, more in terms of implementing policies and what you can do on that end. Employees also have the legal right to refuse to perform work if they have a good faith belief that they will be exposed to imminent danger. Employers should keep this in mind as they navigate the health and safety risks posed to employees by coronavirus. So the first question of the day is whether an employee can refuse to come in, again, because of fear of being sick or being actually sick. Many companies are being flexible with their work from home policies, and some are even encouraging employees to work remotely. I know for many of our clients in the healthcare field, this is not really a possibility, especially for providers. You can't, in terms of seeing patients, it's very difficult to do so remotely unless you have a telemedicine platform. That being said, some of the back office positions, billers, administrators, some of that work can probably be done remotely. It'll be interesting to see what the trend is moving forward. I know here in the New York area, it seems that things are closing on an almost every few minutes. So it'll be interesting to monitor and see where we move next in terms of that. And just keep in mind that if you do have the ability to offer services remotely, it may be a good possibility as well in terms of employee, keeping your employees happy as well. However, not everyone is allowed to work from home, and it's possible that you can be fired if you're not sick and you fail to come into work because you're concerned about being exposed. I would say most employees without a contract are considered what's called at will, meaning they can be terminated at any time as long as the reason isn't illegal. So what would be an illegal reason? If you're firing an employee for being a protected class based on national origin, sex, sexual orientation, background, anything like that. Basically, if you're firing someone because they're a man or a woman, that you can't do that, but you can fire them, for any reason aside from that. Employers should be taking all concerns seriously and should never take action against an employee just for raising concern. So can we ask an employee to stay home? You should actively encourage sick employees to stay home and remind sick employees that may have PTO when they are sick or caring for an ill family member. If an employee recently returned from a trip to a country with a coronavirus outbreak, such as China, Iran, Italy, Japan, South Korea, you may ask those employees to complete a self-monitoring quarantine period for up to 14 days. So some other considerations, Kieran, I believe this is your slide.
Okay, some other considerations, and Michael, I'm sorry, I just lost my slides.
Yep.
First question should be, what are the implications, if any, if you do plan to temporarily close one or more of your offices in connection with this pandemic? And what are the legal requirements, and do the Federal Worker Adjustment and Retraining Notification Act, or WARN Act as its acronym, and New York also has, as do most states, what's called a mini WARN Act, which sort of parallel the requirements of the feds. Normally, if a layoff is big enough, you have to give, under the Federal Act, 60 days notice of closure, or under New York's law, 90 days notice. However, not all layoffs trigger these requirements. And significantly, and again, for those of you outside of New York, check your own state's mini WARN Act. But a layoff of 6 months or less does not trigger employer obligation to give advance notice. So for many businesses who are considering temporary closures, the length of time we're going to be under this cloud is, of course, unclear at this point. But certainly, if it's going to be 6 months or less, or anticipated to be, no warning need be given. The next question is, are temporarily laid off employees entitled to unemployment benefits? And again, this is a multi-state presentation. Unemployment benefits vary state by state, and there are also waiting times. Normally at least a week's wait before one can get unemployment. However, under New York law, to be entitled to unemployment benefits, an employee must be willing and able, and is out actively seeking work. Under New York law, the only time that requirement is not triggered is when an employee has a definite return to work date, a temporarily laid off employee, of 4 weeks or less. So here, with an indefinite layoff, normally the employee would be required to look for work, which could impact your workforce upon your reopening in case they find another, perhaps better job. However, just today, the Federal Department of Labor put out guidance that permits flexibility for states to amend their laws to provide unemployment benefits under these very circumstances, i.e. a temporary layoff due to COVID-19. So we have to see what the states are going to do in connection with this federal guidance, but I anticipate unemployment entitlement laws to be made more lax, or more easily to obtain unemployment benefits under these circumstances, i.e. a temporary closure. My next question was, have you maximized employees' abilities to work remotely? Michael has covered that. Interestingly, one recent survey found that at least 60% of employers have either increased employees' flexibility for remote work or plan to. Next question that some employers have been asking, or should ask: do you have reasonable systems for real-time public health communication with employees? And here, it's really imperative that you employers open direct lines of communications with your employees. Information should come from the top. It should be clear regarding, what you're doing, if anything, regarding infection control, symptoms, a company policy regarding remote work, and circumstances in which employees might be excluded from or allowed to return to the workplace. Again, these communications should be carefully coordinated to avoid inconsistent messages coming from senior management. And there should be, and you should think about this, some organization to maintain current phone, text, and email contact information for all your employees, so that coordinated notifications can come out uniformly and thoroughly. So if you don't have current contact information by multiple means for all your employees, do that immediately, so you have a good communication base to send out notifications. It may be too late for the next one, but have you implemented a business contingency plan? Companies have been putting together these plans to deal with and to minimize business interruptions in circumstances such as what we are presently dealing with. And the elements of such a plan would include perhaps, developing again a telecommuting policy, determining essential functions which must be performed, and if necessary, cross-training employees to cover those job functions where perhaps an employee has gotten ill or is self-quarantined. Again, looking at the legal impacts of a temporary shutdown, which is one of the topics of our discussion today. Evaluating whether open positions can be filled by either temporary employees hired through an employment agency, and perhaps solidifying a relationship with an employment agency in case part-time employees are needed on an exigent or right now basis. Reviewing contractual deadlines to determine how the company will meet those deadlines if a significant number of employees are absent. And communicating with outside vendors and suppliers to confirm that they in fact have their own plans in place, business plans, to deal with supply disruptions and the like. My next question, will my insurance cover any losses? We have been examining on behalf of several of our clients their business interruption policies to see if in fact temporary office closures are required, whether those costs will be reimbursed through insurance. Unfortunately, to date, the policies we have looked at appear to have pretty consistent exclusions for viruses. So if I were you, I'd look at your business interruption insurance, if in fact you have same, and determine whether in fact your insurance contains a virus exclusion or the like. Mike, send it back to you.
Yep. And let's see, where are we going here? Oh. So the next question we have is in terms of payment and payroll and basically paying employees. Do we have to pay employees if we close? Initially, you would be required to pay employees who are absent from work if they have accrued paid time off or pursuant to any paid sick leave law. We'll touch on a few, but as we mentioned, we're focused here on New York law, but we'd be happy to discuss offline if you have any specific questions. New Jersey, Connecticut, Pennsylvania, happy to speak with you on any local or national, around the country as well. We could take a look into that. Additionally, employees may be entitled to paid leave benefits pursuant to state or local laws if the employees are caring for a family member with the coronavirus. So there are state protections in terms of if a family member an immediate family member has the virus, then you need to take care of it. So a sick child, there are certain protections under the law for that. And however, after employees exhaust any paid sick leave, the obligation to pay them depends on whether they are classified as exempt or a non-exempt employee, and whether you are requiring them to be absent from work. We'll touch on the exempt versus non-exempt next. So pay for exempt versus non-exempt. So we'll start with exempt employees. As for exempt employees, you are required to pay them their full weekly salary if they perform any work during a given week. This includes remote work. So if you have let's say a practice administrator who you are given permission to work from home, they start the week off Monday morning, do a few things. You are required them to pay them for that full week, even if the practice decides to close. Moreover, if you are requiring them to be absent from work, such as to self-monitor for the coronavirus at home, you again must pay them their full weekly salary. On the other hand, if they are diagnosed with coronavirus and positive tests and are unable to come to work due to their medical condition, then you likely would not have to compensate them after they exhaust any applicable paid leave entitlement. Again, this is all very new and unprecedented. So while there's no specific case law on it, we are sort of taking what we know, examining what we have put together in the past, and making determinations. Again, stick with us here. For non-exempt employees, you are only required to pay non-exempt employees for the actual hours that they work. Therefore, legally, you do not have to pay these employees if they are unable to return to work after they exhaust any applicable paid leave entitlement. So again, the difference between exempt versus non-exempt employees in terms of salary and the payment. Again, exempt employees, if they start the week, you're required to pay them through the end of the week. Non-exempt employees are different. And if you have any questions on who would be considered exempt versus non-exempt, again, we'll have our contact information at the end, and feel free to reach out. We'll be happy to speak with you on it. So New York City paid safe and sick leave. This is a fairly new, within the last 5 to 10 years, law for those employers in New York City only. If you work in New York City and your employer has 5 or more employees, you will earn up to 5 days of paid leave per year. If your employer has less than 5 employees, you will earn 5 days of unpaid leave. That's unpaid versus paid. Employees can use the leave 120 days after their first day of employment, and for every 30 hours worked, a person is entitled to 1 hour of leave. This paid New York City paid safe and sick leave law, it maxes out at 40 hours per year. So for most employees, it would only cover a week's worth of sick time. This is a problem considering the current guidance on coronavirus that those infected should generally quarantine themselves for 14 days. So obviously there's somewhat of a discrepancy there. Just to be aware for employees that they may not be entitled to the full quarantine period. It doesn't mean you can't give it to them as an employer. It just means under the law, under New York City law, what they're entitled to. Also, you cannot retaliate as an employer. You cannot retaliate against an employee for requesting or using safe and sick leave. Retaliation includes any threat, discipline, discharge, demotion, suspension, or reduction in their hours, or any other adverse employment action against you for exercising or attempting to exercise any right guaranteed under the law. It's pretty straightforward. If you try and fire an employee for using New York City paid safe and sick leave under the law, and your employer in New York City, you can open yourself up to massive liability and fines. So New York State paid family sick leave. This is different. This is statewide, not just for the city. And this is basically workers in New York State have up to 10 weeks of paid leave to care for a family member with a serious health condition. Again, this leave may not be used for your own health condition, and you must have been employed for 26 weeks. So if you have a child who becomes infected, this is what you would, you may want to opt into the New York City paid family sick leave, which you can do, and take care of your child for up to 10 weeks. Again, the intention under the law was for seriously sick or in reference to maternity leave. But again, we are applying this here to the current unprecedented situation.
Mike, if before we go to the slide, This is a very fluid situation, and before we leave sick leave, uh, at least in New York State, Governor Cuomo introduced legislation in January that would mandate certain levels of sick leave for the employees under state law based on the size or the number of employees in the enterprise. Also, today, I believe, the federal government is trying to hammer out legislation in response to this pandemic, which would also provide sick leave, mandatory sick leave, and from what I've read, the possibility of reimbursement to employers for same from the U.S. Treasury, depending on the size, again, depending on the size of the employer, more assistance being given to smaller employers. Yeah, obviously, we are all keeping our eyes on the news, hourly. But for you employers, again, follow the development of these sick leave laws through the state and federal government. I think that progress on same is going to become more rapid as the situation develops.
Yeah, I mean, I think if one of the takeaways you can take, from this webinar is that it's a constantly changing, sort of scenario that we're dealing with, and again, unprecedented, and things seem to be, materializing by the hour. So, it's important to be aware. We're on top of it. If there are any changes, we will certainly, let you know. But I do. Like Kieran mentioned, anticipate that there will be changes and exceptions made for this specific scenario. Again, the key word being unprecedented and fluid. So the federal law on pay, the Family and Medical Leave Act, FMLA, provides up to 12 weeks of unpaid leave if you have a serious health condition or are caring for a family member with a serious health condition. However, the difference here is this only applies to employers who have 50 or more employees. So, it's limited in what it covers. It doesn't cover a lot of smaller employers. So just be aware, if you have 50 or more employees, you're required to comply with FMLA. If you have under, you are not. And another aspect we took a look into was whether employees could try to argue that their jobs should be protected under the Americans with Disability Act, which bars discrimination against workers with disabilities. However, without a positive test, based off our analysis, it appears that the likelihood is slim that this would be possible, that the claim would work. If an employee's coronavirus infection qualifies as a disability under the ADA, they would not be allowed to be fired simply because they're infected. And as long as there's a reasonable accommodation that doesn't impose an undue hardship on the employer, such as working from home, then the employee probably wouldn't be able to be fired because of the fact that employee is in isolation as well. And depending on the circumstances, a leave of absence could also qualify as a reasonable accommodation. An employer may require the employee to provide a doctor's note clearing them to return to work. Also under federal law, employers have no obligation to provide employees with leave, whether paid or unpaid, to remain home with children during an extended school closure. So this is not including FMLA. This is separate just in terms of it, just because schools close, except to the extent provided for in the employer's leave or paid time off policies. Now, however, New York City mandates that employers provide employees with leave necessitated by the employee's need to care for a child whose school or child care provider has been closed by order of a public official due to a public health emergency. So if New York City's schools closed, that would present a whole other set of problems, which we would then address at that time. But to my knowledge, I don't believe that they have not closed schools yet, so there's no public official order yet. So until that happens, that would be an issue then. So here are some steps that you can proactively take, to start immediately in terms of how to protect your practice and what steps you can implement. So educate employees on the virus and transmission. instruct employees in a verbal or written communication to wash their hands frequently and avoid touching their own eyes, nose, and mouth. Provide employees and others entering the workplace with tissues, trash receptacles, hand sanitizer, and a place to wash their hands. I hear hand sanitizer is tough to come by. A lot of it's sold out, but so hopefully everyone has some. Communicate available employee health services and encourage employees to obtain the seasonal flu vaccine. Maintain and improve workplace cleaning, maintenance routines, including providing supplies to clean employee work surfaces and electronic equipment. Evaluate existing leave of absence, sick leave policies to determine how to address the various leave scenarios that may arise. And importantly, at the end, encourage all employees to stay home without fear of losing their job. Okay, so for assistance with all employment and labor matters, feel free to reach out to either myself or Kieran. Again, we are available at any time. You can give us a call. If you want to schedule a 30-minute consultation with us, you can do that as well. And if you mention this webinar in general, we will give you 10% off on the consultation. Again, this is to to harp on the fact that this is a constantly changing situation, and that what's in effect today might be different Monday or early next week. We are staying on top of it again, but it is unprecedented and fluid, and so we are doing our best to stay on top of it. But again, if you want us to consult with us directly, we'd be happy to do so. Just give us a call, leave us a message. If we don't get back to you, we will, or shoot us an email as well, and we'll be happy to discuss. That is today's webinar. I hope everyone stays healthy, safe, and has a great weekend. Thank you guys for listening.
Thank you.